What is up? I'm Mr. Terry. I'm a high school history teacher. Welcome back to another History Teacher Acts video. All right, big news came out recently that the Supreme Court made a decision clarifying rules of immunity for American presidents, and it's caused a lot of heated reactions. And I think we all knew LegalEagle was going to cover it. Now, I haven't seen the video, but it looks like you can tell what the feelings are because literally on the thumbnail it says, "We're effed." So are we? Is it hyperbolic? I want to see what they have to say. And you can respectfully give your opinions down below in the comment section. All right, let's check this out. All right, so I'm definitely into political history, but a lot of things when it comes to law, I am still very much a student of. Go to people like Mr. Beat and stuff for a lot of that stuff, especially like Supreme Court cases and things like that. So I think I'm going to be, learning a lot and trying to learn from a lot of different perspectives. I've already seen social media blow up, and that's such an awful place to form opinions, but we'll see what we got. And of course, a very popular, opinion when it comes to that is our friend John Krasinski here.
However bad you think it is, it's worse.
Ooh,
remember when Trump's lawyers argued that he could SEAL Team 6's political rivals, and we all laughed because that's a preposterous thing for anyone to argue, and absolutely no serious person could possibly believe that the Constitution or the laws of this country would allow that to be the rule. Well, the Supreme Court just said, hold my beer while I assassinate my political rivals.
The president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold.
Yes, the Supreme Court has effectively given law-breaking presidents, and we're not singling any one law-breaking president out or anything, could be any felonious president, almost absolute immunity from criminal prosecution. And where the court did not grant outright absolute immunity.
So I'll tell you real quick, just so you know a little bit about what I've heard thus far. I read like the syllabus of the Supreme Court ruling, but not the 120 pages or whatever that's off of that. But it seemed like what was talked about, and I can get corrected here, was that actions that can be deemed as presidential actions versus non-presidential actions can differentiate what immunity looks like for a president. So if it's something that's done as an official act, then you cannot be criminalized for that. But then if it's a non-presidential act, then you can be. I don't know how vague that's going to be if I have to look into the finer details of how are things going to be separated between presidential acts and non-presidential acts. So is something like Watergate, would that have been a presidential act? But then they're talking about, like with this one with Trump, like the Stormy Daniels thing, like that was not one. So you can be charged with a crime or something like that. So, but I know the big thing about this is about it potentially setting a precedent, right? Supreme Court set precedent about things going forward that will be referred to when other legal cases come back, where this ruling can be ruled again to guilt or say if something's punishable or not. So that's just a little bit of, because again, this just barely happened as the time I recorded, of what I've learned thus far, or what I know so far.
It gave presumptive immunity and procedural protections that might as well have been absolute immunity. And while unofficial acts of the president still receive no immunity, the crap cherry on top of this crap sundae is that even though a president now has immunity from criminal prosecution for official acts as president, a prosecutor cannot even use official acts as evidence in a prosecution over unofficial acts, which makes prosecution of some unofficial acts virtually impossible.
So the thing I've heard now talking about is the idea that people are fearful that a president can basically just do whatever they want, including going after their political opponents, which has been something that's been fought against as a defense, especially for like Trump is claiming that this stuff is happening, that's happening to him. This, these law cases and things are an act of prosecution of him as a political opponent. That these things wouldn't even be going on if, he hadn't been president, or he is not eligible to be president again. So I was wondering how this is supposed to fix that. Does it make it worse for a potential president that wants to go for a second term? Does it make it better for them? Because it's like, if you just declare it a presidential act, if say the judicial system, President Biden or something says, yeah, I suck. I sent the DOJ to go and, look at this stuff. But it's like, is that a presidential act? Does that mean that you're like immune to that? This is where I've got to learn a lot more about this.
Whether you are a Republican or a Democrat, this is a terrible decision for democracy. Possibly a top 5 worst Supreme Court decision of all time. Happy July 4th, everyone. But just how bad is it? Well, don't take my word for it. Justice Sotomayor says, quote, "The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country, and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because
so what I need to learn is all of that actually possible? Like Sotomayor, she's saying that again, that you could send a president could send Navy SEAL Team 6 to go assassinate a political rival, and you're immune. Is that actually what this ruling grants? That's what I know. Or is it hyperbolic? Now, another thing that people talk about this is, 3 of the Supreme Court justices were appointed by Trump. So a lot of people think it seems like that there's nefarious activity going on by these, by having the Supreme Court in numbers that would favor his issues very heavily.
Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Justice Sotomayor concludes that the opinion marked a sea change in the relationship between the people and the president. Quote, "In every use of official power, the president is now a king above the law." But how did we get here? Well, until now, executive immunity was a court-created doctrine that shields presidents from most civil lawsuits involving conduct that occurred during their presidential terms. There's no explicit constitutional text granting the president immunity, but in Nixon versus Fitzgerald, the Supreme Court ruled that a president is entitled to absolute immunity from legal liability for civil damages based on his official acts, including acts on the outer perimeter of his duties. The court defined the president's official duties quite broadly to prevent future presidents from being sued for, quote, virtually every allegation that an action was unlawful or was taken for a forbidden purpose. The court explained that it was, quote, settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the president of the United States. To determine whether a particular type of suit against a president or a former president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. Indeed, in Clinton versus Jones, the Supreme Court found that under that rubric, the president does not have immunity from civil suits for conduct before they became president. So until now, virtually every lawyer and judge in the country assumed that while executive immunity would shield civil lawsuits because the president could be sued by almost anyone in the country over almost anything, that criminal prosecutions would be different.
So this is where the court cases for President Trump are a little bit different. If you have like the Stormy Daniels thing versus January 6th events, that one would be seen as presidential because he was in office then. If he was a part of that or instigating or whatever it is, these decisions, Supreme Court decisions are such a big deal. And at a time where it seems like a lot of America, for example, is losing faith in certain institutions, a lot of people say they've lost a lot of faith in the Department of Justice, like the DOJ, and how it's weaponized for political favor. People already have always had criticisms and certain hesitations about like Congress, that lobbying is such a like protected activity. So you have like these different branches of our government, and is our judicial branch now up to the top with the Supreme Court now going to be seen again as more of a politicization. Although it's always been like the Supreme Court has always been a political tool. It doesn't drastically change as much as it did during like the Trump years, because having three Supreme Court justices appointed by one president in one term is like insane. Biggest things like that has happened would be like expansion of the Supreme Court and the court packing of, FDR. So what a long-term effect will that have for American politics here? Because I think everybody hopes that Supreme Court justices will think long-term, not just in current political situations, but what precedent is this going to set for generations to come?
Why? Because it's way more important that a president be bound by criminal law and not commit heinous criminal acts, even in service of their duties. Plus, there are way more safeguards against criminal prosecution than civil suits. But Trump moved to dismiss his D.C. prosecution on immunity grounds. He lost to the trial court and appealed the decision. Judge Tanya Chutkan stayed the criminal proceedings pending the outcome of the appeal. The D.C. Circuit upheld the lower court's ruling that, quote, former President Trump has become Citizen Trump with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. The Circuit Court ruled that presidents are not above the law.
But you think it's different because he can run again?
The president has a constitutionally mandated duty to take care that the laws be faithfully executed. As part of this duty, the president is responsible for investigating and prosecuting criminal violations. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The Circuit Court's decision was widely praised as a well-constructed opinion that came to the only logical conclusion. But then it arrived at the Supreme Court.
He's coming down hard.
Ruling from the majority of the Supreme Court.
He's not talking about any of the nuance. I wonder if they are going to talk, if he's going to talk about the nuance. Is this going to totally center around what happens with Trump, or again going to talk about more of the long-term effects?
Presidents cannot be indicted based on conduct for which they are immune from prosecution. Based on the standard that this opinion creates, which we'll talk about in a second, Justice Roberts, writing for the 6-justice majority, kicked things back down to the trial court. Quote, on remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution. And the parties and the district court must ensure that sufficient allegations support the indictment's charges without such conduct.
So it still seems like on a case, it seems like just from that, it's going to have to be a case-by-case basis for each potential criminal act. And I guess having to determine if it's an official act or an unofficial act. Will it actually change anything? Does it just open the door to be seen as immune?
It starts with the premise that presidents have lots of power, powers they wield exclusively and do not share with Congress. The court describes the president's core powers as taking care that the laws are faithfully executed, commanding the military and dismissing officers he has appointed, and pardoning people who have committed crimes. So the court created 3 buckets: core official acts, non-core official acts, and unofficial acts. But as you'll see, there's very little difference between the official acts, and very little will qualify as an unofficial act.
By the way, what do you guys think of pardoning power by like governors, presidents, the idea that you can pardon somebody for crimes? Do you feel like that's a good thing? What do you think? Let me know down below.
And the court states, quote, we conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official acts, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. And do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. So with respect to the exercise of core powers, the president is apparently absolutely immune from any criminal prosecution related to using those powers. And the court goes on to note that in cases involving Richard Nixon and Aaron Burr, judges recognize that the president has a presumptive privilege to withhold certain papers and communications. Though oddly, in both of those cases, Presidents Nixon and Jefferson were compelled to produce records
There's a presumption of immunity
because of the public interest in those records was strong enough to overcome the presumptive privilege.
So is it, if it's a presumptive immunity, does that put it a lot more on the prosecution for the burden of proof to say that they're not immune rather than just defaulting to a position saying they're not immune? Like, it's got to be what's shown with unwielding unanimous burden of proof. I don't know if that would be by a jury or something like that.
However, the court sees the Trump case differently because Trump is the subject of a criminal prosecution. Quote, criminally prosecuting a president for unofficial conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession, as in Burr and Nixon. The danger is akin to, indeed greater than, what led us to recognize absolute immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. So the argument goes, if a president could face criminal prosecution for his official acts, including communications with his aides, he might be unable to perform his official duties because he fears prosecution. So the court concludes, quote, taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the
outer perimeter of the official, the circle of official responsibility. Is that still going to be vague? One thing I'm thinking to myself is, what problem is this fixing that's been a problem for a sitting president? Because there are so many things, you know, that international courts of justice or something would love to, you know, get involved in something, and nothing ever happens. So like, what is this in response to?
Effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. But what you'll see is that the majority continually only looks to one side. They believe that presidents should be free, But what about the other side? Sure, there are reasons why we want a president to have the ability to take action, but we also have some damn good reasons why we might want the president to hesitate, if not withhold action entirely when it comes to criminal violations.
Sure.
And the majority just simply doesn't address the other side.
Because we do the same thing with congressmen, right? People are always going at them for crimes. Is there supposed to be a difference between the role of the president and, say, a senator? Yeah, they've been accused of a lot of conduct.
The majority sets up a paradigm that first examines whether the conduct involved one of the president's core powers. If it does, the president is absolutely immune from criminal prosecution. If it does not implicate a core power, then the courts have to decide whether the president's acts are official or unofficial. If it's an official act, the president is presumptively immune from prosecution. If it's an unofficial act, then the president is not immune. So how do we determine if the president's action is part of their core responsibilities or not?
That's the million-dollar question, right? Isn't that the only question, honestly, that matters here?
Well, we don't know. There's no standard in this opinion.
There's no
there are
list
apparently,
of
according
things.
to this court, whatever powers the president has that are not shared with other branches of the government. But it's not like those powers are just listed in the Constitution. And other than the few powers that were explicitly enumerated by this court, including removing people from office and commanding the military, we have no idea what might be considered a core power or not. But even
so, I guess with a core power or not. So does that just then mean that anytime something might potentially come up for a prosecution, it's going to go back to the Supreme Court every single time, isn't it? Rather than having some precedent then go off, because they're not going to have a lot of precedent to go off of. Is it just going to be the current political affiliations of Supreme Court justices at that time, which again could change depending on who's the president and who is sitting on the Supreme Court? Again, I'm trying to think, as like somebody who communicates history, I'm actually thinking about the future in all of this. I'm trying not to fixate on the current situation going on, because that's fleeting. It's going to be gone here very, very soon. So I'm trying to think of the effects of this.
those enumerated core powers are terrifying, because the court specifically said commanding the military. So if you take one thing away from this video, it's this. Because commanding the military is apparently a core presidential power,
he's the commander-in-chief.
Use of core presidential power is absolutely immune from criminal prosecution. Any use of the military by the president, including using the American military on American soil, is absolutely immune from criminal prosecution. And if you take two things away, it should be that the president can do anything related to the DOJ, create sham investigations, sham prosecutions, fabricate evidence. They can do any of that, and they are absolutely immune, because
this seems like it's more about the response is that Trump is seen as a political target, because again, he can still win another term as, as president. I mean, that's got to be right. I know it's all centered around the Trump, but that's it. Does that then mean all this other stuff, these things are just going to keep happening again, actually going to happen more now? Is this actually going to do the opposite of what it seems like it's intended to do, which is to reduce these prosecutions, when in fact what's going to happen is the current sitting president will do more of it themselves rather than, I guess, it happening to them, which again has not been something happening a lot for a lot of sitting presidents. Presidents have gotten away with many things over time, whether it's, again, use of the military, using the CIA for coups or something like that. We know there's all kinds of nefarious things that goes on in the government.
Function. And a few really good commentators put it this way: the office of the president is like a gun. When you get elected president, you have an unfettered right to use that gun any way that you want to. Your motives and purposes for using that gun are completely irrelevant. You're the president, use the gun however you want. Criminal law does not apply to your use of that gun. And that is why multiple Supreme Court justices are concerned about a president SEAL Team 6ing their political rivals. But some official acts are only presumptively immune. So how would a prosecutor overcome the presumption of immunity that comes with non-core official acts?
Right.
Well, again, we have no idea. The court doesn't provide a standard. The only thing the court says is that, quote, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. This is barely a limit. There's almost no reason to distinguish between core and non-core official acts if there's no limit on what can be an official act that receives immunity. This language is from the original Fitzgerald balancing test, but turned on its head. Instead of balancing the importance of the intrusion, the court simply says if there's any danger at all of intrusion, there is immunity that attaches to that action. As Justice Sotomayor said in her dissent, quote, "No dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. According to the majority, however, any intrusion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient hardly matters." Now, I've seen a few legal pundits say that this decision is no big deal because immunity only attaches absolutely for the exercise of core presidential powers, despite—
That's what I've heard. To try to balance that out, and the immediate responses I've seen from different outlets and different pundits and stuff like that.
The fact that the military is almost certainly a core power and lets the president drone strike their rival.
Because core powers, I mean, you got to understand the constitutional rights of the president, again, are vast, very impactful. Again, commander in chief, or head of the military, right? So you have that going on. Again, they can veto things that come, from Congress. They are big. Our president does have a lot of power.
But it's okay because other official acts are only presumptively immune and therefore can be prosecuted. But based on this language, that's not the case. Given that the only official acts that can be prosecuted are ones where there is absolutely no danger of intrusion into the authority and functions of the executive branch, that category is vanishingly small.
Well, should that then cover the whole SEAL Team 6ing your political opponent? Is not going to let you be immune?
Worse, you can't look to the president's motives to determine whether the act was official or not. Now, even if you're president and you murder your political rivals and receive protection, you'll still want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So
if you are wondering if you have immunity for whatever crime you're accused of, call them.
Click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below. Okay, sure. But unofficial acts are not immune, right? Well, hold on. First, how would we distinguish a president's official actions from his unofficial ones? Well, the court says, quote, "When the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office." However, the court then says that official acts are not constrained to the president's constitutional and statutory authority. The majority says, quote, "And some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official conduct when not obviously connected to a particular constitutional or statutory provision. For those reasons, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority."
So that then sounds like, say, again, the other accusation is playing some kind of role directly, indirectly to what happened on January 6th. That then seems like that is on that outer fringe. By saying it's something like constitutionally tied powers of the president. So that seems like from that, then you could be prosecuted if there's evidence for having a role in like January 6th.
So if you think that sounds like a very broad description of presidential official acts, you'd be right. I would be challenged to come up with a broader definition. But surely plotting to overturn an election result would be manifestly and palpably beyond the president's authority, right? Wrong. The Supreme Court said, quote, "In dividing official from unofficial conduct, courts may not inquire into the president's motives." According to Roberts, even asking the question would cripple the executive branch's ability to function. And it gets worse. According to Justice Roberts, quote, "Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law." So if a president's action violates a law, that doesn't mean he can be prosecuted.
Well, when the president does it, that means that it is not illegal.
As Justice Jackson points out in her dissent, the government will have difficulty proving whether an act is official or unofficial since it can't introduce evidence of the president's motives. That's right, the court says you can't look to the president's motives to determine whether an act is official or unofficial either. For reasons. The only question is whether the president has the power or not. And Justice Jackson points out the problem with this means-only or authority-only approach in her dissent in a footnote. She says, quote, "To fully appreciate the oddity of making the criminal immunity determination turn on the character of the president's responsibilities, consider what the majority says is one of the president's conclusive and preclusive prerogatives, the president's power to remove those who wield executive power on his behalf. While the president may have the authority to decide to remove the attorney general, for example, the question here is whether the president has the option to remove the attorney general by, say, poisoning him to death. Put another way, the issue here is not whether the president has exclusive removal power, but whether a generally applicable criminal law prohibiting murder can restrict how the president exercises that authority.
By the way, are there more statements clarifying from the justices that voted yes on this? You know, I'm hearing from Sotomayor and Jackson, but like, I want to hear their arguments and their perspectives.
And the implied answer in that footnote is that the president is free to poison any member of their staff or cabinet because they have authority to remove that person. They've got the power, so any means whatsoever would be an official act. And I'm not being histrionic here.
So like, rather than firing, so what would be the benefit then to poisoning them rather than just firing them? Because if that is within the job description of a president doing that, because usually it's people you can't remove on your own that you'd think would be a motive for removing someone from power. Unless you're trying to do some kind of political sidestepping where you don't want to look like a bad guy for firing this person, so you have them mysteriously die. Is that what it's going to be?
Justice Sotomayor says the majority allows the president to send SEAL Team 6 to kill their political rival. Justice Jackson says the majority allows the president to poison any member of their staff. This isn't just me. These are the dissenting justices on the Supreme Court. This is what I meant when I said this was bad. And this policy argument on which they 100% rely stems from the idea of separation of powers. But it also turns that idea completely on its head, because part of separation of powers is checks and balances. And here they've organized things in a way that the executive is completely unchecked by either of the other branches of government. And while the majority opinion is 43 pages long, it never got around to defining unofficial acts. So while it provides tons of guidance on what is an official act and is therefore immune from prosecution, they give zero guidance whatsoever on what is an unofficial act and therefore would be prosecutable. All we know is that official acts which are immune are anything within the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. That's almost anything a president does. So the court has also made the official versus unofficial distinction almost meaningless.
So it's not just based off of constitutional roles of the president, because that seemed like the thing that would most logically, I guess, defend a president, because that's their constitutional right. You know, you may have some kind of constitutional protection as like a citizen, like your freedom of speech or something like that, but not necessarily in the job description there. So
as Justice Sotomayor says, in fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly or palpably beyond his authority, he's taking official action. It then goes a step further. In dividing official from unofficial conduct, courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability.
Distract them from their duties.
Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. So to help understand all of these distinctions, the great people over at Justice Security put together this great chart. Starting from right to left, if there is official conduct, we have to ask, is it within the core constitutional authority? If it is, there's absolute immunity, no prosecution, and you can't use it as evidence.
By the way, I still do want to see the justices that voted for it. Right, so it's 3 dissenting, pretty much on party lines. I want to see their response to this, because it looks like we're just seeing from the dissenting. Like, what would they think of this breakdown? Do they think this actually, do they agree to this, these different types of conduct?
If it's not core constitutional authority, you have to ask, does it pose any danger of intrusion on the authority and functions of the executive branch? If it does, no prosecution, can't use it as evidence. If it doesn't pose any dangers of intrusion on the authority and functions of the executive branch, then there is no immunity and you can use it as evidence in a prosecution. Then going back up to the top of the chart, if the conduct is 100% unofficial, then yes, you can prosecute it. But remember, you cannot use any official acts or anything that was deemed an official act as evidence in that particular trial. Now, when courts address constitutional questions, they're generally bound by principles of judicial restraint. Now, the consequences of this decision are not just about Trump. It applies to all presidents for the foreseeable future. And that's why it's important to understand the criticisms of this decision and why it's so dangerous. So let's start with one of the court's first big leaps, the idea that immunity shields a president from criminal as well as civil penalties. Why did the majority grant such sweeping immunity? Well, according to the majority, quote, the purpose of a vigorous and energetic executive, the framers thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. They pull that line out of context from...
Yeah, what? Okay, I'm stopping too much, but yeah, what the heck? Are they saying it without saying it?
Federalist 70. And that's about it. You apparently can't have any enfeeblement whatsoever of the president, even though every president for the last 250 years has assumed they could be criminally liable for at least some of their conduct. But that's it. That's all the support they have. It's just a policy argument that a vigorous,
and it's like they're saying that's a bad thing like the ruling, and saying it's a bad thing for them to have to worry about their conduct. When it seems like if you ask most people, wouldn't they want them to be worried about their conduct? Does that keep some kind of thought of accountability for your actions?
Presidency is good, therefore almost full immunity. QED, from proclaimed originalist and textualist, this is honestly shockingly dishonest and hypocritical. Because we're dealing with the Constitution, Congress can't pass a law that says the president will be criminally liable for virtually anything, and the judiciary can't prosecute the president. So the president is unchecked. And the majority opinion doesn't even address the public's interest in not having a criminal president. As Justice Sotomayor points out in her dissent, the court's precedent suggests that presidents do not and should not have broad immunity from criminal law. Quote, at the same time, the public interest in federal criminal prosecution of a former president is vastly greater than the public interest in a private individual's civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Berger's concurrence accordingly emphasized that the majority's immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting justices agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. And the ramifications of declaring the president above criminal law are huge. Justice Jackson explains, quote, put simply, immunity is exemption from the duties and liabilities imposed by law. In its purest form, the concept of immunity boils down to a maxim, the king can do no wrong, a notion that was firmly rejected at the birth of our republic. And as
they're like invoking like Louis the 14th here, like that's moi, like I am the state. They're referring back like, okay, this is now they're getting into my wheelhouse of the other rulers of history that have obviously had complete unimmune thing. Divine right of kings, the idea that, you know, kings are basically infallible because they're appointed by God. But I know some people hyperbolically are saying that's, you know, that's what we're going to, right? We don't need to be back on that path.
Justice Sotomayor explains, quote, the majority makes 3 moves that in effect completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official act immunity is inconsistent with text, history, and established understandings of the president's role. Moreover,
man, the dissenting judges are pissed. You could just see them seething through this. I think trying to maintain some role of professionalism.
Moreover, it is deeply wrong, even in its own functionalist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary hearings is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. The main takeaway of today's decision is that all of a president's official acts, defined without regard to motive or intent, are entitled to immunity that is at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptively, cannot touch him. The official acts immunity has no firm grounding in constitutional text, history, or precedent. Indeed, those standard grounds for constitutional decision-making all point in the opposite.
That was something I've been trying to think about too, and trying to learn from this is the historical context, the historical precedent of this. At least she's saying like there's none. Again, that's what made me think about this is what problem was this trying to solve that has been a problem in our country's history?
Direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible.
There's got to be
now, the 6 conservatives in the majority, all of them self-described,
that goes deeper than what's going on.
Were really offended by this comment. They say that, quote, a specific textual basis has not been considered a prerequisite to the recognition of immunity. And Justice Roberts tries to rebut Sotomayor by noting that the Constitution is silent on all matters related to prosecuting ex-presidents. Quote, conspicuously absent is the mention of the fact that since the founding, no president has ever faced criminal charges, let alone for his conduct in office. But that's entirely Sotomayor's point. She says the Constitution's silence is noteworthy in at least 3 respects. Quote, First, the framers clearly knew how to provide for immunity from prosecution because they did give narrow immunity to legislators via the speech or debate clause. She says, quote, they did not extend the same or similar immunity to presidents. This is classic textual interpretation. If you're bound by the Constitution and the Constitution grants immunity in some places, but is silent as to immunity in other places, that immunity doesn't exist. Her second point is that some state constitutions did provide express immunity for sitting governors, but the Constitution did not. Again, calling into question the reason the framers did not extend that privilege to a sitting president. And the third contention was that the impeachment judgment clause cut against the court's position. Quote, that clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, and judgment and punishment according to law. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as bribery. So there's no other way to put this. This is a horrifying opinion. And I personally worry about the future of this country. For one reason, we can't change this. There's no one to appeal to. Congress can't fix this with legislation. We can't appeal to the courts because the highest court in the land says that the immunity exists and it's almost always absolute. The Constitution is the highest law of the land, and it's effectively like the Supreme Court has amended the Constitution to include an immunity that has never existed before with zero basis in the text and history of the Constitution.
I guess that means the Supreme Court's going to have to check the Supreme Court at some time, but obviously that won't happen till the Supreme Court, changes heavily in its justices, which is going to take years and years for that to happen, for, new justices to come in that might have different perspectives.
All we can do is hope that future presidents won't use this power. This is horrifying not only for those that think former President Trump committed crimes while in office, but for anyone that believes the president should be bound by the law. As of today, for many, many actions, regardless of their inherent criminality, the president is immune. And even if you believed every crazy thing that has been alleged about Biden and the Biden crime family, this decision would immunize almost every allegation that has been levied against them. And of course, the shadow of Trump's actions.
That's kind of what I'm thinking. I'm hoping, I've said this multiple times, I want to hear the other side of this, people that have supported this, is what does this fix? And it can't be just a one-sided political thing where it's just like, no, only like Trump Republicans will like this. No, it affects every president. If you have these claims against whatever your opposition is, like the Biden family, like he's saying, that then is going to protect him too. So is it one of those things where they see that that's fine? Like, as long as my guy's protected and my future guy's protected, I don't care what happens to the others. Is that just what we're saying in general? It's just like, if my guy's protected and I don't care what happens to your guy? Is that the win for people to think this is a win? That why that's a win?
It's large, but I wouldn't want this opinion to come down during any presidency. Nor does any serious jurist think that this should be the law going forward. No president should have this immunity. No president should have this power. And perhaps someday the Supreme Court will scale back this opinion and provide reasonable definitions. But as it stands now, current and future presidents have the powers of a king.
That could take a long time.
This is bad, and I frankly can't think of anything worse. And that's also reflected in the news reporting as well. What's interesting is that the Supreme Court decision has been covered extensively by over 400 news outlets. 33% of the reporting coming from the left, and only 17% coming from the right. But if you compare the headlines, you'll start to see some interesting framing emerge. On the left, you have a lot of outlets saying that Trump was granted immunity. On the right, outlets tend to draw the distinction between official acts and private acts. And depending on which article you see first, your view of the story can be completely different. If you read the left-leaning sources first, you might think that presidents have complete immunity and only focus on the potential negative outcomes, which frankly is more accurate. And if you read the ones on the right, you might fail to see any of the potential repercussions from this decision.
What did that one say? So they're already using this. Breaking Trump wins. Supreme Court rules 6-3 on presidential immunity. Court holds that a former president has absolute immunity for his core constitutional powers. Yeah, so they're already like this thing is framing it as a win only within the context of the present and not the future.
Now, all this is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, which could be run by total nutjobs. And I also love their blind spot feature, which shows you stories that were underreported by either side of the political spectrum. And it helps explain why we often talk past each other and some people seem hyper-focused on what seems like nonsense.
Like philosophically here, this seems like a good service. Yeah, like the idea of just seeing that. Because remember, most people have no idea. They don't know their blind spots. They don't understand bias because you're in a vacuum.
Often because some random blog post went viral among certain groups. But that's why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by clicking on the link that's on screen or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below to get 40% off your subscription. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.
All right. So what he was saying in that ad was something I wanted to make sure what I was going to talk about here in my conclusion was, one thing I've learned as somebody studying history is taking in lots of different sources. And it's more important than ever right now because we have so many sources of media, so many sources of information. And like what they did in this video, I mean, all of it was looking at the dissenting justices' opinions on it. You can see very, very clearly how hardcore they are against this ruling. But, like I teach my students, you have to try to absorb as many pieces of evidence as possible. Now, in my just initial looking at what the media has been saying, people on social media are saying, is by far more that this is a negative thing. I've seen little sprinklings in there of how it's a good thing. What I need to make sure, and I think we all need to make sure, is where are those blind spots that we have? For example, we live in an algorithmic world when it comes to media. The more you consume of one type of media, the more you're going to be exposed to the same type of media, especially when it comes to like political bias. So if you go on Twitter, you go on somewhere else, anything that is presenting things to you, all right, that you didn't necessarily go and seek out, but it's putting it in front of you. Remember, that was created based off of what you generally look at. It's important. I want to make sure that I develop, my ideas about this, understanding that there's still a vacuum. There's an echo chamber. And as much as we all want to say we are in echo chambers, it's impossible to not be in one with how media and how things are covered right now. So that's the thing about echo chambers, though, is you have to on your own crawl out of it. Nothing out there is going to get you out of it. You're going to have to go manually and go look at those other sources. So that's what I want to see next. That's what I want to see next, to see that. And then you can make your opinion like, okay, are all these people, again, that are so against this, are they being hyperbolic or are they truthful in it? Especially because, as you saw there, a lot of it is vague in this ruling here. So because the worst case scenario of whatever this ruling could be, it could be really, really bad. Something down the road could be very bad to whatever structure we're calling our government as a republic, democracy, etc. It does seem like the worst case scenario. Seems like it's a lot worse than whatever the best case scenario is going to be. But I want to make sure I'm accurate with that. All right, with that, you guys, we'll see you next time. Bye.